Welcome to Washington Legal Foundation's web seminar program. My name is Glenn Lamey. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 42nd year of free enterprise litigation, communications, and publications. We are involved in a wide variety of issues, trying to advance a notion of the law that's supportive of, not detrimental to, free enterprise, job creation, and economic growth, and economic liberties. One of the things that we do are programs such as these. We also do media briefing programs, a wide variety of publications on, again, a wide variety of issues. And as I mentioned, the litigation is sort of our core area of work. For those of us who do work in the field of the law and policy, especially for those of us who do it in Washington, D.C., acronyms are rather ubiquitous. So ubiquitous that they can be tiring. But once you hear the one you'll hear the most often today, PFAS or PFAS, is a bit of a godsend, given that saying it, what it represents out loud, can be challenging, but I will do it once and only once. Per and polyfluoroalkyl substances are a class of several thousand different man-made chemicals whose uses, like acronyms in DC, have become quite common throughout society. And like most man-made substances, they are not without risks. And where there is risk, there are regulators, lawyers, activist groups, and investigative reporters who together create risks for the makers of those substances and also the users of those substances. We've seen the iron triangle, as tort law legend Victor Schwartz has called it, of litigation, public relations, and regulation focus its attention over the past several decades on products like asbestos, tobacco, and most recently products like prescription drugs, With PFAS, we are now seeing a rise in private and public litigation, state and federal regulatory and legislative actions, alarming claims by environmental and health activists, and even a movie that was recently screened for Hill staffers and members of Congress. Our speakers today will discuss how we got to this point, where the litigation, regulation, and public relations are going, and the lessons learned from past products liability crusades that might apply to PFAS. Our speakers are Anne-Marie Duffy, who's a partner with Hollingsworth LLP here in Washington, D.C. She has a broad experience in the defense of complex civil litigation, including commercial, medical device, fraud, and intellectual property cases where billions of dollars are at stake. She's also briefed and argued appeals to the United States Court of Appeals for the 10th Circuit and the DC Circuit as well. Also speaking today is Frank Leone, who is a partner with Hollingsworth as well, where his broad litigation practice encompasses environmental law and defense of toxic tort, consumer product asbestos, and pharmaceutical product liability claims. For 2019, Mr. Leone is named once again to the Washington, D.C. edition of, please cue the theme music, Super Lawyers. He's a member of the Virginia Association of Defense Attorneys, the National Association of Railroad Trial Counsel, the International Consumer Product Health and Safety Organization, and the Product Stewardship Society, which are all almost as much of a mouthful as PFAS. So I will hand it over to Anne-Marie. If you have a question during the program, please feel free to ask it using the question and answer template next to the screen.
Thank you very much. So today we're going to talk to you about PFAS, give you sort of a lay of the land, where the litigation stands, and some key defenses and questions to ask as you're preparing your defenses. So let's start from the beginning. What are these chemicals? So the PFAS chemicals are known as forever chemicals because they are environmentally persistent. They do not biodegrade. They do not go away once they are in the environment. They're also bioaccumulative. And there has been some evidence that there could be a carcinogenic potential with respect to these chemicals. So that's why they're of concern right now with the regulators and in litigation. The chemicals were created by 3M in the 1940s, and they've been put to lots of good use. They are very helpful in that they are fire resistant, some of them. Some repel oil, stain, grease, water. So you'll find them in all sorts of products. You'll find them in cleaners, textiles, leather products, paper products, paint, wire insulation. But the health effects are concerning, and the environmental persistence is concerning. Two of the most common PFAS chemicals that are the subject of regulation and litigation today are PFOA and PFOS. So what are they? PFOA is the acronym for perfluorooctanoic acid. It is a chemical that was used to make DuPont's Teflon and other products, other surfactants like Teflon. The surfactant that we see most commonly in the litigation is PTFE, or polytetrafluoroethylene. PTFE is a surfactant used to coat various different products like frying pans in the picture here, but also used to coat fiberglass. Sheets of fiberglass are coated with PTFE, laid out on large cutting tables, and then cut to create various shapes and sizes for use in a lot of different industries. This fiberglass can be cut to used for belting in car engines, grill sheets for fast food restaurants, even tape. PFOS is another PFAS chemical, perfluorooctane sulfonic acid. This chemical was used not only in firefighting foam, but also household products like Scotchgard used to be made in the Scotchgard manufacturing process, and other stain repellent materials. So let's take a look at what the federal and state response to date has been with respect to these PFAS chemicals. Over the course of time, the EPA has issued a series of notifications and limits. So let's start from the beginning. In the 1990s, almost 50 years after these PFAS chemicals started to be manufactured by 3M, the EPA starts to grow concerned about these chemicals. And the concern arises from its discussions with 3M in that time period. 3M relays to the EPA that it is aware that PFOA has been found widespread in the blood of the general population. And 3M reveals that it has also found small amounts of PFOA in the environment as well as in human blood. They also disclose that there are some health concerns with respect to laboratory animals. So at the end of the 1990s, in 1999, 3M stops manufacturing PFAS, but other companies take up the mantle. DuPont actually starts manufacturing PFOA after 3M shuts down its manufacturing process. In March of 2002, we see the EPA's first significant new use rule published with respect to PFAS chemicals. This new use rule requires that manufacturers notice the EPA before any future manufacture. And this first rule only encompasses 13 PFAS chemicals. But over time, the EPA continues to expand the significant new use rule to cover more and more PFAS chemicals. In December of 2002, October of 2007, October of 2013, and then January of 2015, the list just keeps growing over time. In 2003, in April of 2003, the EPA launched an investigation into PFOA specifically. On April 16th, 2003, the EPA published its concerns about PFOA, and that publication also identified a number of gaps in the information and data that the EPA had with respect to that particular chemical. So the EPA negotiated with a number of companies and parties to obtain that missing information and that missing data. They used enforceable consent agreements, memorandums of understanding, and other voluntary commitments to get that information. In July of 2004, the EPA's Office of Enforcement and Compliance Assurance brings an administrative complaint against DuPont. They allege at this time that DuPont's in violation of the Toxic Substances Control Act, or TSCA, and the Resource Conservation and Recovery Act, RCRA. The allegations against DuPont are that as early as 1981, DuPont had observed and knew of PFOA in the blood of its pregnant employees. And these were employees at the Washington Works, West Virginia facility. The allegations also included that one worker had passed PFOA in utero to her fetus. The allegations also assert that in the mid-1980s, DuPont knew that PFOA had been found in water supplies close to the facility. EPA's ultimate allegation was that DuPont failed to inform them of these substantial risks of injury to human health and the environment. That action was settled in 2005. It was, at the time, the largest civil administrative penalty the EPA had ever obtained. DuPont paid $10.25 million to the EPA. In this settlement, DuPont also agreed to pay $6.25 million for supplemental environmental projects, projects dedicated to investigating the potential of its products to break down to PFOA, and also some local projects in the school system of Wood County, West Virginia. In 2006, the EPA launches the PFOA Product Stewardship Program, and this was a very important program that yielded a lot of information for the EPA. The first reason this is so important is because the EPA was able to get 8 of the leading manufacturers of PFOA to agree to reduce the manufacture of the PFOA chemical. And the commitment was to reduce the manufacture by 95% by the year 2010. The second reason this product stewardship program was so important is because it yielded what ended up to be a mass balance analysis, or a study of how the PFOA, when manufactured at manufacturing facilities, went through the process and ended in the environment. And also users and purchasers of products made with PFOA voluntarily participated in this program and studied how much PFOA was coming into their facility and thus leaving out into the environment. The third big value that came out of the product stewardship program was that the group was able to establish scientifically credible analytical standards and laboratory methods for actually measuring the amount of PFOA in soil and water. Prior to this time, there were few, if any, laboratories that had developed any protocols or analytical standards for this testing, and there was little agreement among these laboratories about how best to do it. So that was a very helpful product of this stewardship program. In January of 2010, the EPA published its first amendment to the Toxic Substances Control Act, amending the polymer exemption rule to now exclude certain of these PFAS chemicals. The EPA believed at this time that it could no longer conclude that the excluded polymers would not present an unreasonable risk to human health or the environment. And then this year, in February of 2019, the EPA launches the PFAS Action Plan. The goal is to better understand PFAS and reduce the risk to the public. And in April of 2019, the EPA released its draft recommendations for addressing groundwater contamination of PFOA and PFOS. Throughout this time, the EPA has also looked at the health risks associated with PFAS chemicals, PFOA and PFOS in particular. In January of 2009, the EPA issued its Provisional Health Advisory, which is a non-enforceable, non-regulatory advisory, which set the amounts of PFOA and PFOS below which there is no health concern at 0.4 parts per billion for PFOA and 0.2 parts per billion for PFOS. The EPA was very frank that these limits were set very low to be overly cautious, and they are not meant to be read that amounts above this are necessarily harmful or hazardous. In 2014, the EPA issued its draft health effects document, which detailed potential health effects from consuming PFOA and PFOS. And in May of 2016, the EPA issues its formal health advisory, which sets the PFOA and PFOS limits much lower than before at 70 parts per trillion. And then just earlier this year, the EPA also has published that it believes there's suggestive evidence that PFOA and PFOS may be carcinogenic in humans. So what is the 70 parts per trillion? This is sort of what it breaks down to. 1 part per trillion is approximately 1,000 times smaller than a drop of water in an Olympic-sized swimming pool. So this is an exceedingly low limit for the amount of PFOA and PFOS that can be in drinking water. So what is the current state and the anticipated state of federal regulation? Currently, PFAS chemicals are not designated as hazardous yet. There is no drinking limit set for these chemicals as of this time. However, at the 2018 National Leadership Summit, the EPA announced 4 action plans. First, they're going to investigate steps to evaluate the need for a maximum contamination level for PFOA and PFOS. Then they're going to start the steps necessary to designating PFOA and PFOS as a hazardous substance. They're developing groundwater cleanup recommendations, and they're developing toxicity values for the next generation or the replacement chemicals that have been used after the phase out of PFAS. Those are known as Gen X chemicals and PFBS chemicals. So a small number of states have followed suit following the EPA guidance and starting to set health advisories and some public water limits for PFOA and PFOS. Several states have adopted the EPA's 70 parts per trillion limit: Alaska, Colorado, Connecticut, Massachusetts, and Michigan. But some states have gone lower. They have set much lower limits than the EPA has. For example, Minnesota has set a health advisory at 35 parts per trillion for PFOA and 15 parts per trillion for PFOS. Vermont and Wisconsin have set limits of 20 parts per trillion for both of these chemicals. And then New York and New Jersey have set the lowest limits we have seen around the country at 10 parts per trillion in its health advisories. We understand that Pennsylvania is currently evaluating whether it will also set health advisory and water limits. And then North Carolina is currently investigating setting health advisories for the Gen X, the next generation of these products. So what are the PFAS risks, and what are their health hazards? So we know that they're environmentally persistent. These chemicals are very soluble and very mobile. So they're everywhere. PFOA has been found in the Arctic. It has been found in the blood tissue of polar bears. It is all around the world. And it will not go away. It does not biodegrade. And with respect to health hazards, what we do know is that it does bioaccumulate. It accumulates in the blood, and it stays there for a period of time, though it does have some half-life in the blood. If you were to stop consuming PFAS chemicals today, it'd be about 3.5 to 4 years before your blood would be cleaned of all PFAS chemicals. So the studies that have been done to date, there have been a number of animal toxicity studies that have been done, primarily in rats and mice, though a lot of other animals have also been studied: fish, guinea pigs, chicken, monkeys. Lots of animals have been looked at. The conclusions in these laboratory studies are that the PFAS chemicals accumulate largely in the liver, kidney, and serum. And so your primary effects are liver toxicity, developmental toxicity, and immune toxicity. But one thing to remember with respect to these laboratory studies is that the animals that are being studied here are given very high doses of these chemicals, much higher doses and much higher exposures than even those who worked in the manufacturing facilities, so much higher than the occupational exposures that we've seen. With respect to the human studies, the largest study that's been conducted is known colloquially as the C8 study, or the C8 Health Project. This project was designed to look specifically at PFOA. C8 stands for, or is a term that is used interchangeably with PFOA, and the C8 just refers to the number of carbons used to manufacture the chemical. As Frank will talk about a little bit later, this health study was the result of a class action litigation that DuPont was involved in concerning its West Virginia facility. As part of the settlement of that class action, the C8 Health Project was created. And its general purpose was to gather information from 69,000 people living near its DuPont Washington Works facility in West Virginia. They collected information through interviews, questionnaires, and blood samples. And the study spanned about 8 years, from 2005 to 2013. And what they concluded, they weren't looking at or able to determine causation. So they don't have any opinions that PFOA is causative of any health effects. Rather, what they have concluded is that there are 6 health outcomes that were more probably than not associated with PFOA exposure. And these are the 6 health outcomes that they were able to identify. But again, this isn't causation, just association. There have been a series of worker studies that have been conducted since the C8 panel concluded, but the results are a bit mixed. So some of the worker studies have found some trends and associations between PFOA exposure and health effects. The most common health effects are high cholesterol, but also there are some trends towards rheumatoid arthritis, some positive but non-significant trends for prostate cancer, liver disease, and hyperthyroidism. But the remaining studies that have looked at occupational exposure in workers haven't found any associations. No associations with cholesterol, liver disease, or any other disease. So where are we? So the ATSDR, the Agency for Toxic Substance and Disease Registry, just published in June of 2018 a draft report for public comment titled Toxicological Profile for Perfluoroalkyls. And they've got a few interesting findings in here. The first and most important is that they conclude that the epidemiological studies done to date simply do not establish causation of any health effects resulting from these chemicals. But ATSDR does go on to list a number of diseases that are associated with exposure, and they include a few more diseases here than what the C8 panel found. The ATSDR also reports that they found increases in testicular cancer and kidney cancer in highly exposed humans. So there is that observation for very high exposure. So how does one get exposed to these chemicals? So because these chemicals are very soluble and very persistent in the environment, they're very soluble and very mobile, they get into our drinking water and they are in the public drinking water. They're also in bottled drinking water. Surprisingly enough, some have been found. In addition, for the manufacturing facilities at least, there has been evidence that these chemicals got out through air emissions. And so what would happen is the chemicals get out through the air, rain comes down, depresses the chemicals to the soil, the chemicals then stay in the soil, make their way to the groundwater, and then boom, you're getting it through the groundwater as well. But there's also been reported human exposure from products and foods that have come in contact with products made with these chemicals. So Scotchgard used to be made with PFOS. Also certain food and food wrapping materials and containers were made with these chemicals. And in June of this year, actually, the FDA published a poster reporting its studies of 16 PFAS chemicals in various foods. And they found these chemicals in agricultural products, fish, livestock, and they also found a very high level of PFOA in chocolate cake purchased at a grocery store. The theory, of course, that the chocolate cake was wrapped in some sort of food wrapping that was high in this material and it migrated into the chocolate cake. So the most common ways of exposure, really food and water, hand-to-mouth transfer if stain repellent has been applied to, say, a carpet or some other interaction, and then, through these paper products and food products. So what's being done? And I'll hand it over to Frank to talk about that.
Oh, okay. Thank you, Glenn, for having us today. So Anne-Marie talked about these chemicals getting into the environment, and what happens then is typically there's a state investigation because, as we talked about, PFOS and PFOA are not yet CERCLA hazardous substances, so typically it's states taking the lead on this. And recently the state of New Jersey took the lead on it in a fairly unique way and issued a order, or actually directive, finding that PFAS compounds constituted a statewide public nuisance and requiring PFAS manufacturers, including one that didn't even manufacture in New Jersey, to provide information, some to pay past remediation costs, and some to consider paying future remediation costs. But more typically, what happens is there is detection of PFASs in the drinking water. That leads to publicity, that leads to public concerns, that leads to lawyers and lawsuits, and typically off-site testing of drinking water that will see just how many wells and what areas are actually affected. The next step would be to investigate and respond. And companies typically start, since the exposure is with drinking water, typically start by providing bottled water, providing filters for houses where necessary, and where appropriate, providing hookup to municipal water systems. And that has the effect of blunting any current potential health effect to the extent there is one, but also cutting off future claims. People are getting clean water, and so that's a big step forward. But the next step, may well be remediation of soil or groundwater as well. One thing that often happens in these cases, like a typical environmental tort case, is the company works with EPA and or the state agency, and under CERCLA or RCRA carries out a remedial action and thereby gets preemption and defense from private tort cases, particularly those seeking injunctive relief. If you're cleaning up your site the way the state wants you to, then plaintiffs' counsel don't really have a right to tell you to do it differently, broadly speaking. But despite your efforts to prevent exposure and clean things up, litigation happens. And so far, most of the litigation has arisen from drinking water exposure. Anne-Marie mentioned consumer products. There was an attempted class action involving Teflon in the late 2008 or so, but it didn't really go anywhere. So far, not a lot of those claims have gotten very far. The primary claims involve drinking water. They involve individuals. They're brought by individuals who had water that contained PFASs, water districts, and municipalities. The defendants are the suppliers of PFASs, the companies that originally made the chemical, as well as the manufacturers who used the chemical in their products, as well as, for example, water districts that passed on the chemical to consumers. The claims are typically personal injury, property damage, and medical monitoring, depending on the state. And they typically sound in tort, negligence claims, the typical environmental nuisance and trespass claims. But what's a bit different in these cases is also product liability claims, design defect, failure to warn. And we'll talk about this, how those sorts of theories apply to this kind of litigation in a few minutes. So the first wave, and the original title of this talk is PFAS the next asbestos, so I'll answer that question at the very end. But to borrow asbestos language, the first wave is litigation against the suppliers, the manufacturers of the actual PFAS chemicals. And that did start with DuPont in Parkersburg, West Virginia. There was a class action brought in state court on behalf of 70 to 80,000 people who resided near a plant where there were releases of PFOA to the drinking water, to the river, to the air, and then to the drinking water, including across the river in Ohio. Primarily the case was seeking medical monitoring costs. And in 2004, that case was settled, a payment and also filtration of plans for water district wells, and then, as Anne-Marie said, the C8 panel, which found eventually, after several years of looking, found a probable link between PFOA and 6 diseases, but also found no probable link between PFOA and another 40 diseases. But that litigation and that finding really got the ball rolling, I think, in terms of regulations as well. There was so much coming out through the litigation that I think that prompted EPA to act faster than they otherwise would have. And that C8 panel findings have been the basis for a lot of litigation going forward. And the most immediate case that went forward based on that was the PFOA MDL in the Southern District of Ohio. So out of all those people who were potentially exposed, you had allegedly 3,500 who brought personal injury claims, who lived near and or worked at the DuPont facility, and had one of the 6 diseases that the C8 panel found a potential association with. And as part of the settlement, general causation was not disputed. So that as a defendant, that takes away one of your first big defenses. And specific causation could be disputed, but it's not really clear how that actually worked out in the trials. In any case, between 2015 and 2017, there were the first 3 of these 3,500 plaintiffs went to trial. They were all plaintiff verdicts in the amounts of $1.6 million to $12.5 million. And then in February 2017, DuPont and its partial successor, I guess, Chemours, entered into a global settlement where they paid $671 million to settle that inventory of 3,500 cases. And that was the end of the DuPont litigation. Just kidding. Plaintiffs promptly then started filing additional lawsuits, and I believe there are about 40 or 50 currently pending, still arising from that DuPont facility. The first 4 cases are set for trial this fall and next year, and then the court has decided that this has now achieved the status of a mature tort, and it can start trying cases in consolidated groups that will include 5 plaintiffs in each case going forward until those cases are resolved, or forever, whichever comes first. Down the road to the west a bit, the other primary manufacturer of PFASs, 3M, was having its own issues. And the most significant case there is a natural resource damage claim brought by the state of Minnesota. The claim was at DuPont, at 3M manufacturing and handling and disposal facilities that the PFAS had affected the groundwater, it affected the Mississippi River. And the state brought in its experts and sought $5 billion in damages. The case settled in 2018, just before trial, for about $850 million. And that was a case that the defendants had filed a number of motions, but the state court judge basically didn't rule on any of them. So right before trial, there were a lot of questions. In any case, they came up with that settlement. Another result of that litigation is 3M had to produce a number of documents, a number of which you can now find in the internet, and which help fuel some of the other litigation that we'll talk about. There's a couple of other national cases that bear mention. PFOS was used in firefighting foam. Basically, it was a surfactant, and it would help the foam extinguish the fire. And so that was used to fight fires, but more importantly, it was used for training exercises. And then when you spray it all over the ground in a training exercise, it goes into the soil and ultimately to the groundwater. So this is a big issue at military air bases, at civilian air bases, and at other facilities. And so there were about 75 cases that were transferred to a judge as an MDL, multi-district litigation in Charleston, South Carolina. And those involved government water and water district and individual claims alleging damage and exposure via groundwater contaminated with AFFF, which actually stands for aqueous film forming foam, although it also relates to firefighting foam. Those cases are just getting underway. There was an effort to broaden that litigation and basically throw all the PFAS litigation into Charleston, but the judge decided that the AFF cases were enough and the other cases could stay where they were. Back to the Southern District of Ohio, the same plaintiffs who pursued the DuPont litigation brought a class action last year, and it's a class action on behalf of 99% of the United States population that has detectable levels of PFAS in their blood, and it seeks creation of a PFAS science panel. So the plaintiff is a single firefighter who was exposed allegedly to AFF. The class consists of approximately 326 million people, but is growing at a rate of 1 every 14 seconds. And the defendants are PFAS manufacturers and importers. And actually, just to clarify, some of the folks who were involved in the original EPA stewardship program, not all of them were actually manufacturers. Some of them were just importers who used the chemical in their products, but they wound up on the list anyway. And most of those defendants really didn't have anything to do with firefighting foam, by the way, but they are subject to conspiracy claims, which is somewhat of a parallel with asbestos and certainly with tobacco litigation, except for the evidence isn't nearly as strong here as it was in those cases. The complaint doesn't seek monetary damages. It doesn't seek medical monitoring for 326 million people, plus one every 14 seconds. It asks for a PFAS science panel, sort of like the C8 panel on steroids, that would issue a definitive and binding conclusions confirming causal connections between any PFAS, and there are 4,000 of those, by the way, and any disease, sufficient to merit personal injury compensation or future medical monitoring. So the idea is this panel would be set up, it would make decisions on causation that would be binding to everybody in America. It's a fairly audacious effort, to be honest, both in terms of scope and remedy, and defendants, not surprisingly, have filed motions to dismiss on grounds including that there's no injury, there's no causation, and there's no cognizable remedy. Hopefully the judge will view those favorably, but it's a fascinating case. So the second wave, the first wave we talked about are the PFAS manufacturers, primarily 3M and DuPont. The second wave is the users, the folks who used chemicals containing PFAS in their manufacturing processes. Sometimes those chemicals made it through to the final product. Sometimes they didn't. Sometimes the chemicals were used, absorbed, discarded, whatever, in the manufacturing process, but they were nevertheless released. And the seminal case in this group of cases is in Hoosick Falls, New York. St. Gobain and Honeywell had a plant that used PTFE that made, for example, Teflon-coated fabrics. And in the process, there were trace amounts of PFOA that went up the smokestacks and out into the water and the wastewater and the solid waste that was disposed of at the plant. In 2014, EPA got involved, started testing for PFOA in the groundwater, and as Anne-Marie mentioned, came up with standards and progressively lowered them. And then in 2016, in January, Governor Cuomo got involved. That's never a good thing if you're an environmental defendant in New York, by the way. And listed the site as a state Superfund site, issued an emergency regulation classifying PFOA as a hazardous substance. So although it's not so classified by EPA, it is, for example, in Michigan and New York classified, and then asked the state to set drinking water standards. The 10 parts per trillion that Anne-Marie mentioned are a health advisory guidance and a recommendation from the State Water Quality Panel. They have not yet been enshrined in regulations. That regulatory process is just getting underway. And so within a few weeks of the governor's action, plaintiffs began filing a number of class actions. They don't seek personal injury. Class actions typically don't, although sometimes they do. And when they do, that's certainly subject to attack, and we've been successful in attacking them on those grounds. But plaintiffs' counsel who don't want to waste their time are more likely to bring a claim seeking monetary damages for remediation cost. Here we have loss of use and enjoyment of the property, diminution in property value, loss of quality of life, medical monitoring, and punitive damages. So there's a number of cases that are currently pending in federal court. Baker v. St. Gobain is the lead case involving Hoosick Falls. Defendants moved to dismiss, arguing that the property damage claims were not valid because they concern contamination of groundwater and the plaintiffs don't own the groundwater. And the personal injury claims were invalid because New York doesn't recognize medical monitoring as an independent cause of action. West Virginia, for example, does, but New York does not. You have to have a personal injury. And plaintiffs said, well, these people have PFOA in their blood and that's a sufficient personal injury, even though there's no symptom, there's no disease. The court agreed, and so those opinions are now pending before the Second Circuit. They've had oral argument and should be a decision relatively soon on that. Down the road, or down the river, literally down the Hoosick River, you have Petersburg, New York, and there a company called Taconic also used PFAS, containing products. Sorry, I got scared. PFO, which contain PFOA in some way, shape, or form in their products, and there were releases to the neighborhood as well. That's a state court action, and so first the court denied a motion to dismiss. Then it went ahead and certified class. It certified several property damage classes involving plaintiffs who were had their own private wells and plaintiffs who were on municipal water. And it also certified the first bioinvasion class, medical monitoring class involving plaintiffs who are not sick, but who have PFOA in their blood above a alleged national average of 1.86 micrograms per liter. So that case is under appeal in the New York State Court, but in the meantime, the litigation is proceeding. And there have also been a number of personal injury cases. These aren't brought as class action, these are brought as individual cases in both Hoosick Falls and concerning Petersburg as well. Another site where things are going on is Rockford, Michigan, which is just outside of Grand Rapids, and Wolverine manufactured hush puppies there, the shoes, and treated the leather that went into hush puppies and treated it with Scotchgard from 1958 to the late 1990s. It was found in the groundwater. The company responded by providing bottled water and also by providing whole house filters for a number of different houses. But nevertheless, there were 3 class actions that were filed that are currently pending in federal court, and about 200 actions brought by individuals. Most are property damage, some alleged personal injury. And under Michigan's unusual tort reform procedure, Wolverine named 3M as a non-party at fault, and then plaintiffs sued it directly. So both the supplier and the manufacturer are in that case, which is currently in discovery. Anne-Marie talked briefly about paper, and there's litigation involving paper mills. One of the cases is down the road from the Rockford facility. It's a 3M plant, a Georgia Pacific paper plant, and both 3M and Georgia Pacific have been sued. And a number of cases involve military air bases. Most of those cases haven't yet involved the Air Force or the Navy. They typically decide to skip that and go for the suppliers. But there's certainly, and this feeds into the regulatory issues, a lot of Department of Defense concern about this issue, and in fact some provisions in the current Defense Authorization Act that address different parts of it. House bill is different from the Senate bill, and we'll see what comes up through it, but that's definitely an issue. So, how do we defend these cases? The first issue is product identification, and this is somewhat similar to a typical groundwater contamination case. There's something in the groundwater, is it mine? And as Anne-Marie mentioned, PFAS is ubiquitous. It can be difficult to track its fate in transport. And there's an issue of whose PFAS is it, and that's a molecule that shows PFOS up there. You see the 8 carbon chain as the background. The other molecules are fluorine, and the reason why it's a forever chemical is the carbon-fluorine bond is extremely powerful. Things like PCBs hang around an awfully long time as well, but carbon-chlorine is not as tough as carbon fluorine, which makes it wonderful to use for a lot of products, but does give rise to issues of concern when it gets in the environment, and particularly when you're looking at standards at the parts per trillion level, which would be an order of magnitude, for example, lower than drinking water standards for things like trichloroethylene or the other chemicals that we're more familiar with in the environment that we have to deal with. So whose PFAS is it? You know, if you look at landfills, if there's a landfill facility near yours, there may be a number of different sources. Were there fires or fire suppression training in the neighborhood? Groundwater flow direction, hydrogeology, all that becomes important. And then wind direction becomes important, because this is unlike your typical trichloroethylene or VOC case, where if the TCE gets into the atmosphere, it volatilizes and it goes away. Here, the particulate gets into the atmosphere, it comes back into the soil and finds its way into the groundwater. So that's the first question: is it ours? Then there are legal defenses. There can be a number of different types of claims, but they're typically tort claims. And so the first issue is negligence. And of course, negligence consists of a duty and breach of that duty. And so the suppliers, like 3M, have argued that they don't have any duty to the people who are drinking the water. they're just a supplier, and so they have sophisticated user or bulk supplier defenses. And we also see this, maybe we can do a talk sometime on 1,4-dioxane, which is the next emerging chemical. There's not as much litigation on that yet, but it is starting to get going. And for example, in Long Island, there are 23 cases brought against Dow and other suppliers of 1,4-dioxane. And there, this is going to be one of the key issues as well, is does the supplier owe a duty? Several courts, however, have denied motions to dismiss by the suppliers, finding that at least a duty was alleged. Exercise of due care is an element of a negligence defense, and here you're talking about something that for years was referred to as an emerging chemical. I think by now we can say it's probably emerged. But nevertheless, if you were handling this chemical in 1960, 1970, you wouldn't be particularly concerned about disposing of it. I mean, EPA still hasn't listed it as a hazardous substance. So I think that's definitely a defense that companies can make when you have a chemical that didn't even become an environmental concern. How, in exercising due care, could you be expected to handle it differently? But as I mentioned, so we've got nuisance and trespass, the typical environmental cases that you will have in environmental contamination, but then we've also got product liability cases, and I think the closest litigation is the MTBE litigation. MTBE was a gasoline additive to address oxygenation of gasoline, and it's more mobile than gasoline in the environment and has a lower taste odor threshold. So there was an MDL established in Southern District of New York. One case was tried and went up to the Second Circuit, where the city of New York recovered, I think, about $108 million from Exxon for contamination of a well field in Queens, by the way, that it had never used and will never use because it was also contaminated with PCE. But anyway, the Second Circuit there upheld a verdict against Exxon, and one of the basis of the verdict was failure to warn, that Exxon should have warned service stations that the gasoline that contained MTBE was likely to be more mobile and more noticeable if it wound up in people's drinking water, therefore don't spill it, as opposed to normal warnings to gas station owners not to spill gasoline. Seems kind of strange to me, but it was good enough for the jury and good enough for the Second Circuit. And so that's I think, the similar kind of path that plaintiffs will try to follow in these kind of cases alleging failure to warn type theories and other product liability theories. There's a no entry defense. If we talked about PFAS accumulates in blood, but its presence in the blood isn't necessarily an injury. I mean, until we could detect things in parts per trillion, you might not have known that you had it in your blood. And it certainly doesn't necessarily manifest a symptom. And in New York, as we mentioned in the Baker v. St. Gobain case, the defendants argued that the case should be dismissed because New York doesn't recognize medical monitoring in the absence of an injury, and the presence of chemical in your blood that's non-symptomatic doesn't constitute an injury. Part of that challenge is Doppler Challenges to plaintiffs' toxicology and epidemiology experts and the information they rely on. And Anne-Marie talked a bit about that. We've got animal studies that are just based on, female mouse liver weight things. I mean, we could spend a lot of time talking about it, and I'm sure there's some science behind it, but the extrapolations that are required to come to any kind of human effect are extraordinary. And the epidemiology, as Anne-Marie mentioned, is mixed. Most of the epidemiology concerns people who worked in plants, who are exposed to far higher levels than most other people ever would be. And in most cases, there were not associations. But nevertheless, plaintiffs do rely on that argument. And the other thing they rely on is regulatory standards. So you take the mouse studies and then you factor in uncertainty and then another level of uncertainty and a third layer of uncertainty while you're at it. And that's where you get to 70 parts per trillion. It's quite certainly, that doesn't mean that people exposed to that level are actually going to experience these adverse effects. And so there have been some Daubert proceedings that, unfortunately, the lead case is one that came out on Monday of this week. It's another St. Gobain case. It doesn't involve Hoosick Falls, but it involves another facility up the road in Vermont, the Sullivan case. And there, plaintiffs brought a medical monitoring class action, and the defendants brought a Daubert motion to exclude the plaintiffs' experts on hydrogeology, on air transport, on natural resource damages, but also on medical monitoring and epidemiology. And the court in that case recognized that research and understanding of PFOA health effects are incomplete, that the plaintiff offered evidence of only potential health effects, that plaintiff's epidemiologists talked about the risk to human health but said nothing about actual causation, and that the CE8 panel itself found there's no proof of cause and effect from their evaluation of PFOA. So a court applying Daubert properly would say it's plaintiff's burden to show causation, and there has to be scientifically reliable evidence to get to that. And nothing that we have here, potential association based primarily on animal studies or overly conservative overly conservative, maybe appropriate for what they are, but nevertheless, conservative regulatory standards don't show causation, don't provide reliable evidence. Plaintiff's experts' testimony is therefore excluded, and without experts' testimony, summary judgment for the plaintiffs. But that's not what the court said. The court said it was all good enough and it was a subject for cross-examination, and clearly it's a judge who needs to read some of your WLF publications on Daubert and be educated about how to properly apply it. Property damage cases. So as we mentioned, sometimes plaintiffs do bring action seeking injunctive relief in these kind of cases, but where you've got remediation underway, they have no business doing so, and so you may be able to defeat those sorts of claims. You may argue that there's no actual property damage. I mean, you've got chemical present in the groundwater, formerly present in the groundwater, at parts per trillion levels, but what property is damaged? And in Hoosick Falls, they said, well, my shower is damaged because it has particles of PFOA in it. That's not typically how we think of property damage. In some cases, and this is the one thing the judge in Sullivan got right, plaintiffs alleged that there was damage to the groundwater. And the court said, well, as individual plaintiffs, you don't have a claim for that. The municipal water authority may have a claim for that, but you don't. And that was the right answer. And then there's property values, and there's a whole different area there. Is are plaintiffs' properties really being devalued because of this situation? Is it permanent? Is it temporary? Do they have to show a certain level of contamination on their property in order to recover for diminution of property value? Can they recover for stigma? And that's an expert-intensive and very important issue that these cases will resolve. So one thing that does make this litigation a bit unusual is the issue of suits against suppliers, and that typically doesn't happen. It typically didn't happen in asbestos litigation, although it did happen in the Kelly Moore versus Union Carbide case. Kelly Moore was a joint compound manufacturer, contained a fraction, 1% of asbestos that it got from Union Carbide's chrysotile plants in California, and Kelly Moore decided to hire Mark Lanier, a very famous plaintiff's lawyer, to represent them in a suit against the supplier, Union Carbide, alleging fraud. And it ultimately didn't go well for Kelly Moore. They wound up losing, and also in the process made statements about their product that probably was not the best in terms of defending the underlying cases, and then they filed for bankruptcy not long thereafter. So I guess asbestos is a case where maybe you try something like that. But these cases are a bit different. But there are actions that are being brought against the suppliers. And so you have to consider, is it worth it to do that? What's your business relationship with your supplier? What are the legal bases for the claims? What information did the supplier provide regarding the waste handling? And more importantly, what information did the supplier have and not provide? And so these are all the issues that are being litigated currently in some of these cases. And then the timing of the lawsuit is of course important. Do you want to just deal with the plaintiffs and then bring the contribution action, or do you need to bring the supplier in as part of the existing litigation? And in many cases, plaintiffs are just jumping to it and suing the supplier anyway, so they're in your case whether you like it or not. So what are some of the future litigation trends? There's some areas that haven't come up yet, but will. We talked about paper, certainly textiles, leather goods. PFASs were used to suppress mist in electroplating facilities. So we know about chromium in electroplating facilities and issues that we've had with chromium in groundwater, frankly, since the 1940s. But the issue of PFAS is new. So we'll be looking at those cases and perhaps more user litigation, more consumer product litigation. So far, as I mentioned, it seems like there hasn't been a whole lot of that. But that's a potential new frontier. And then another frontier, let's call it the third wave, is the replacement PFAS chemicals. So these are shorter than the C8 chains, or C4 or C5. And what does that mean? Well, it means that they have a lower bioaccumulation potential. They're more likely to get flushed out. Nevertheless, they're not likely to get much smaller than C4 or C5, and they're going to remain in the environment, and they're going to remain mobile. And the toxicity of those chemicals is still very much at issue. So some manufacturers were smart enough when this was coming along to replace their C8 with non-PFAS chemicals, but others went with the lower, the safer chemicals. But that is an issue that is open for discussion, and certainly there's an interest in Congress and elsewhere, and public interest groups and so forth, in looking at the shorter chains as well. So, is PFAS the next asbestos? No, not really. First of all, asbestos is still asbestos, and my firm's been doing it for its entire 35 years and is still doing it, and will probably continue to do it for indefinitely. One of the differences between asbestos and PFAS is you have a different exposure route. PFAS is primarily a drinking water issue. Asbestos is an air issue. If you're walking down the street next to the World Trade Center, then you've got an asbestos issue. There's no signature disease. The first disease that was associated with asbestos is asbestosis, which was a fibrosis of the lung with factory workers. There's no PFAS-osis yet, nor is there likely to be. Asbestos is also associated with mesothelioma, rare cancer that does have background rates, but there's nothing like that. I mean, the diseases we're talking about with PFAS are things like high cholesterol, right? I mean, that you can't get less of a signature disease than high cholesterol. The health risks are unproven. And we've talked about that, and so far there hasn't been a whole lot of product litigation. But nevertheless, it's still a very serious litigation threat. In verdicts and settlements, it's already exceeded $1 billion. New suits are being filed every day. And as long as you have a regulatory standard that looks at levels in the low parts per trillion, you're going to have potential litigation out there. And I think that's... Anything else to add?
That's it for us.
Okay.
Thank you. Again, if you have questions in our online audience, you can use the Q&A template and send them in. But just add the first question for Frank, which is, for those who may not understand what the term mature tort means, if you could clarify what that means and what that means in terms of the implications of bringing 5 or more cases together.
Yeah, it's Francis McGovern, who's a professor at Duke, I believe coined that term a few decades ago. And the idea is in a normal litigation, you have to go through the normal litigation process, and you have to prove all these things, and you have to do it on an individual basis because different plaintiffs have different claims, and they're entitled to their day in court, and the defendant is entitled to hear those claims without a lot of confusion. Mature tort is sometimes used as a way to short-circuit that process. We've already decided asbestos causes diseases, so we can just do this in an accelerated process, and we're not really worried about your due process rights. And the court, in a recent opinion, I think it's May of this year actually, in the PFOA MDL in Southern District of Ohio, used that language to say, by now we're far enough along, and that we could just go ahead and try these cases 5 at a time. We've tried 3 of them after all, and involving different diseases. So I'm not sure that I would apply that definition to this litigation that involves 4,000 different chemicals and very, very weak science and a lot of individual differences when it comes to things like high cholesterol. But nevertheless, it's judicial shorthand for I'm going to use a shortcut to screw the defendants.
You had mentioned that a number of states are looking at different levels of parts per million for PFASs. What's the practical implication of that? It would seem that it would be somewhat different from having different labeling standards for food or those sort of things in terms of the implications for litigation. But if you could get into that a little bit.
Sure. Yeah, there are a couple of things. And Michigan, for example, had a 70 parts per trillion standard that adopted in 2018, at the beginning of 2018, and then they appointed a panel that came up with new standards that are far lower. And the panel, incidentally, composed of 3 people, including 2 who were plaintiffs' experts in the underlying litigation, which one might think was a concern, but the state of Michigan didn't. And so what happens? Well, number one is those levels will set cleanup standards. And so that means you might be able to get by without doing a whole lot, but if you have to clean up the groundwater to low parts per trillion levels, that's going to be a significant effort. It's going to result in big, huge plume maps being shown in your local newspaper. The people who live over that plume are going to be concerned. So the regulatory actions will really drive tort actions as well. And then in addition, when it comes to causation, and again, the regulatory standards have all these assumptions that don't fit the standards for actual medical causation. But, to the extent the court will let them in, it makes things harder. And it really is, I'm not sure how, I hesitate to suggest this, but I'm not sure how EPA has grappled with the fact that the levels for these PFASs are so much lower than most of the other chemicals that have been out there for a long time. And not to say that those chemicals should have lower standards as well, but it's coming to a point that if you can detect it, you need to get rid of it. And that might be one approach, but it's not necessarily a health required or economically or even environmentally sound approach.
One of the things that is going on also are suits by water treatment plants and other water-related public utilities as well, and they don't have to show causation. They don't have to prove a lot of the standards that private plaintiff would have to prove, and they're also suing for cleanup costs or filtering costs.
Correct.
If there are a good number of outcomes against the PFAS manufacturers, what effect does that have on the personal injury type liability suits?
Well, it does, it increases the concern about the issue. To the extent that the water was, number one, tested and found that it didn't have PFAS, that's good news. To the extent that it's being treated and so exposure is being cut off, that's good news. But you're right. I mean, for a water district, they can bring a circle action to recover their costs of putting in remediation. Or they can try to bring tort actions. And New York, by the way, just recently passed an extension of the statute of limitations that basically makes it very easy for any water district to bring a claim following the Second Circuit ruling that actually applied the statute of limitations to water districts. So, when you've got the taxpayers on one side, it makes it a challenge. Now, from the defendants, they still have to show causation. I mean, they still have to show that it's your, or at least try to show that it's your PFAS. Although in the MTB litigation, the issue of market share or alternative share or some new theory that the district court judge came up with, it's sort of like that, was allowed to proceed. It wasn't the basis for the verdict. But, and for example, the current 1,4-dioxane litigation in Long Island, plaintiffs are basically bringing a market share theory. There are 3 manufacturers of 1,4-dioxane, so if it's in the water, it has to be one of you 3 guys, is the approach.
It's a good segue into my next question, which is the implications of a hazardous substance designation for CERCLA, where you have joint and several liability what impact would that have both in cleanups at the state level and also litigation?
Yeah, well, I think a lot of the state actions are proceeding under the state standards anyway, and under the state equivalent of CERCLA. So, does it make a huge difference? I'm not sure. It may make a huge difference to the Department of Defense, for example, and how those sorts of operations work. If it there have been some disputes, for example, as to whether, PFAS isn't a hazardous substance, but is it mixed with a hazardous substance? Does it become, therefore, hazardous waste and therefore a hazardous substance, and can it be regulated? So there's that issue has already come up in the litigation. I'll see if Anne Marie thinks differently, but I think it's likely that Congress, regardless of what Congress does, I think it's likely that EPA will at least identify PFOA and PFOS as hazardous substances, although the current legislation just says PFAS in general, and that's 4,000 chemicals, and that's not usually Congress's job.
Well, and for a lot of these litigations too, the uses of these PFAS chemicals happened in the past when the chemicals weren't designated, hadn't been designated yet, even under state law, right? So some of the state court cases in New York, these companies were utilizing PFOA containing products, but at the time, with all of their regulatory compliance, all of their different environmental regulations that they were abiding by, they didn't have any requirement to treat it as a hazardous substance. So even if it gets designated by the EPA now, I don't know how much that will affect previous users and manufacturers of the product.
So looking at tobacco and opioid litigation as an example, do you see any chance that there'll be sort of a multi-state, state AG coalition type action being brought, or so many individual state suits against the manufacturers or users that they'll have to be combined together at some point, like they were in the
Interesting.
Ohio?
Yeah, it's an interesting question. I mean, the AFF, there's already an MDL, and some of those are municipalities. Some states have started to bring actions. I think New Hampshire or Vermont has. Michigan is looking at it, looking at a statewide action. So that process hasn't gotten that far along yet, but it's certainly something that with activist attorney generals, and in some cases, New York handles these cases itself. Other cases bring in outside counsel to pursue these kind of claims. That is something that you might well see. That's a good point.
Yeah, actually.
I don't have any further questions. I guess we'll wrap up. I want to thank you both for joining us today. Excellent presentation. For those of you who are online, if you joined us late, by any chance, this program will be available in its full form on our website later this afternoon. And I wish everyone a good day.
Thanks for having us.
Thank you very much.